Like the office they commemorate, presidential libraries are living institutions. Certainly it is my hope that the Reagan Library will become a dynamic intellectual forum where scholars interpret the past and policymakers debate the future.
Welcome to the Ronald Reagan Presidential Foundation and Institute's virtual event series. To fulfill President Reagan's mission of making the Reagan Library a dynamic intellectual forum, our Center for Public Affairs Programming offers lectures and forums presenting perspectives on important public policy issues of the day. Each year, we bring you 20 to 30 events from politicians, authors, members of the media, business and military leaders, and more. Since the March 2020 closure of many businesses across our great country, the Reagan Foundation is now bringing its events online to ensure that we are still delivering world-class content, even if you can't get to our hilltop to watch it in person. In this week's Center for Public Affairs event, we present American jurist and academic Douglas Ginsburg for his new book, Voices of Our Republic, Exploring the Constitution with Ruth Bader Ginsburg, Alan Dershowitz, Sandra Day O'Connor, Ron Chernow, and many more. Judge Ginsburg serves as a judge on the United States Court of Appeals for the District of Columbia Circuit, a position he was appointed to in 1986 by President Ronald Reagan. He served as the chief judge from 2001 until 2008. In 1987, speaking of Judge Ginsburg, President Reagan said, "He believes, as I do, that the proper role of the judiciary is to interpret the laws, not make them. He believes that in our democracy, it is for the elected representatives of the people to make the laws, and that unelected judges must never attempt to substitute their private will for the will of the people." You see, Judge Ginsburg remembers, as I do, the warning of James Madison, that if the sense in which the Constitution was accepted and ratified by the nation is not the guide to expounding it, there can be no security for the faithful exercise of its powers. Judge Ginsburg has gone on to write many books on the Constitution. His newest book, Voices of Our Republic, is a companion piece to his three-part 2020 PBS series, A More or Less Perfect Union, which he also talks about with us today. Voices of Our Republic features thoughts about the Constitution from personalities, dignitaries, and everyday heroes who help answer the question of why the Constitution is so important and how it can be applied to political discourse today. Each person emphasizes a different part of the Constitution, from the Bill of Rights to the 19th Amendment and beyond, and why those particular passages are important, serving as a key resource for those looking to better appreciate the foundation of American government and to increase our understanding of its application during its initial creation and still today. We now invite you to enjoy our virtual program, coming to you from our Air Force One Pavilion Leadership Academy Oval Office, with Judge Douglas Ginsburg and Reagan Foundation and Institute Chief Learning Officer Anthony Penny.
All right, welcome everyone. My name is Tony Penny and I am the Chief Learning Officer at the Ronald Reagan Presidential Foundation and Institute. Today it is my honor to have Judge Douglas Ginsburg with us. He served as Chief Judge of the U.S. Court of Appeals for the D.C. Circuit from 2001 to 2008 and has been on that court since 1986. He worked in the Reagan administration and has taught law at Harvard, George Mason, the University of Chicago, Columbia, and others. We're really excited to have you on today, and we're really excited to talk a little bit about this project that you have been working on. So it's kind of a combination of things, right? So it's both available on Amazon Prime, a video series, a three-part series called A More or Less Perfect Union, right? As well as a companion book. So if I could ask you, Judge Ginsburg, what was it that made you want to do this?
Well, thank you, Tony, for asking. This is addressed to what I think is a real crisis in our education system in the U.S. now, in that civics is not being taught as nearly as widely as it should be. Even American history is often neglected. So we have millions of students graduating each year from high school who have never been exposed to how our government works, what our Constitution says, what our national values are even. The younger a person is these days, the more ignorant they're likely to be on these topics. And we simply cannot have a functioning democratic republic with a completely ignorant population, but we're heading in that direction. And what I'm doing is part of a broader reaction to that desuetude in civics education. I think Sandra Day O'Connor really started the ball rolling a dozen years ago when she resigned from the court. There's iCivics. What is it? IZZIT.org is doing. They created educational materials from the series that I did for PBS. And indeed, they distributed the series to 170,000 teachers of history and civics. So we're going to reach about 1 million students a year for as long as the issues remain pertinent. And I'm sorry to say, I think that's going to be a long time. So I'm hoping that this will hasten the movement to restore civics to our basic educational system. In the last year, 4 states have done just that. 2 legislatures and 2 governors have required it: Massachusetts, Florida, Texas, and Illinois. And I'm hopeful that there will be many more coming this year and the next.
Excellent. Well, that certainly is a noble cause. I remember when I first started here, so I've been on board here about 10 years. My very first person that I interviewed was Justice O'Connor. And she talked quite a bit about launching iCivics and how important it was. It was. I'll share a quick favorite moment that we'll jump back. But one of the students got up and asked her, how do you reconcile your personal opinion when you are making a decision on the Supreme Court? And she looked at the audience and she said, bring me my purse. Somebody bring me my purse. So her person was with her, brought her purse up on stage, and she dug around it and she said, I don't reconcile my personal opinion. I reconcile it with this. And she pulled out a copy of the Constitution, which was just a beautiful moment for civic learning and the importance of the Constitution, which is one of the reasons while I was watching your series and looking through the book that you put together. It absolutely is very, very important.
The framers anticipated this problem, and of how do you make judges loyal to the law and to the Constitution. And their solution was, for federal judges, lifetime appointment, no potential reduction in salary ever. So there's nothing to fear. The oath is to the Constitution, and there's no other competing value. You leave that behind when you take that oath. And you have every reason to do so.
Yeah, well, absolutely, absolutely. Well, and I want to say, as we come into this, just the context for our audience. So it's the day after the election, which still has not been decided. We're still kind of, votes are being counted. And we are in a country that many would argue, is polarized as it has been in a long period of time, that we have such a division between, our political ideologies and the people who adhere to them. And in your introduction to the book, you wrote, running through that variety, so you talk about the variety of people who contributed, is a consistent sense of the centrality of the Constitution in American life. In a big and diverse country, which the U.S. has been since the moment of its founding, the Constitution is what unites us. So I was wondering if, given the context of the current political moment, and you talked about the lifetime appointment of judges who are kind of, in some ways sheltered from, the politics of the moment, right? How do you see the Constitution helping restore kind of this America that's united around a single document and set of ideas?
Well, we are still united around that document and set of ideas because that's what we argue about. What does it mean, and how should it be applied, and should it be changed? And that intense partisanship and division and divisiveness that you're talking about was with us right from the beginning. I think you know your history. I think you've taught history, if I recall. And the early American Republic was almost, if not more partisan and divided than we are right now, at least as much so. Newspapers ran constant invective against one candidate because they were in secret correspondence with the other candidate. There were outrageous claims made by each side against the other, personal maledictions and malefactions and so on. It was extremely bitter. And it's been that way pretty much, well, not maybe every year, but off and on throughout our history. It's nothing new. And certainly I've lived through it before, through the Watergate era, just as recently as a year ago. The attempt to impeach President Trump was a real spectacle of civics at work, because what were the people in the Senate and the House arguing about? The meaning of the impeachment clause. what could be an impeachable offense in 1789? That was the question. They were arguing about it. Now, they don't have to agree. As long as they're both arguing about that, the republic is safe.
Yeah.
Arguing about should we just disregard that, overthrow it, then we'd be in real trouble.
Yeah, absolutely. I love, and I think you do such a great job of this in the series of setting up this idea that really the country has been about, kind of the battle over those ideas that are embodied in the Constitution since the very beginning, right? If we go back to, the Constitution, the convention itself was a battle of ideas that played out over the course of the summer of 1787, right?
And an important aspect of that is that the Constitution that emerged was the product of several important compromises. Legislatures make compromises, or legislators do, in order to get anything done. And that's something that we've become less good at, I'm afraid. At least our legislators have become less good at that. But that is what makes the polity work. And of course, courts don't operate that way. In courts, somebody wins and somebody loses. In the legislature, it's ordinary politics and horse trading, and everybody goes home with something and not everything that they wanted. But we accept that as legitimate output. That's what we agree to live by.
Absolutely. Well, it's just interesting, too, the way that kind of discourse, if you think about, now I think the clash of ideas happens on Twitter in very short form, right? You think about, the original clash of ideas, the Federalists and the Anti-Federalists. I mean, these are long form, thoughtful, philosophical essays that helped kind of make the case for the Constitution in the first place, right?
Remember, bear in mind, they appeared in newspapers, in daily newspapers. Okay.
Yeah.
That was the medium of dissemination. So they were longer than today's op-eds, to be sure. And generally more persuasive and more elegantly written, but they were addressed to the public. The Constitution is addressed to the public. It was put out from the convention for ratification by we the people. It was meant to be understood by the people. It was not meant to be something you have to be a lawyer to read and understand. I mean, clearly it helps to study, but you can get a good idea of the Constitution, its structure, and its purposes simply by reading it. You need a lawyer to read the mortgage to your house or a deed. You don't need a lawyer to read the Constitution and understand it.
It is kind of amazing that if you buy a house, likely the document is going to be 5 to 10 times as long as the document that kind of sets up the legal system for the United States, right?
It is a relatively brief document. It's on 5 large pages of parchment, handwritten.
Yeah. Well, and you point out, I love the video. I love, there's scenes of you talking with reenactors at Independence Hall in Philadelphia and kind of engaging with the founding, which in some ways this video series is. It's an engaging with the founding and trying to reconnect Americans to the founding of the country. And you highlight a phrase that I know people who are involved in civic learning use this example quite a bit to talk about the importance of civic learning. And that's what Dr. Franklin, when he emerges from the convention, and he's asked in the streets, what have we got, a republic or a monarchy? And he turns to the person who asked the question and says, a republic if you can keep it. And that, I think, has become kind of a rallying cry for people who believe in the importance of civic learning, like as I know you do, having created this as certainly as a focus of our work here. In some ways, do you think that constant battle of ideas is how we keep the republic?
Well, in a way it is. I think that's well put, because in a republic, we're represented indirectly through elected officials. It's not a democracy. We don't vote, you and I, on whether to adopt this or that law. Sure, there's the occasional referendum or initiative in California where you are and many other states, but by and large, the legislature makes the laws. We just make the legislators. And they sort themselves out into parties. They did so almost immediately. The framers didn't anticipate that. They didn't want that, but that's what happened. And it's that constant exchange of views and proposals and so on that keeps the republic vibrant and contemporary. And one of the important points that comes out of the show, and I think we'll get into it, is that the Constitution and the laws under it are not updated by courts or they shouldn't be anyway. They're updated by the constant political interaction among the people and their representatives.
Absolutely. Well, let's get into it a little bit, because I know there are some certain parts of the show and your work that you wanted to pull out. It goes back to 1803 in the case of Marbury versus Madison and the concept of judicial review. I'm going to toss it to you. So why is that important for folks to know?
Okay, well, it's absolutely foundational. It comes in 1803, very early in the Republic, in which Chief Justice Marshall, known as the Great Chief Justice, reasons as follows. We have a written constitution. And in another place, he says, by the way, that's the greatest innovation in political life, I think, ever, something like that. We have a written constitution. It's what the founders, the framers agreed to, and what the people of the states ratified and agreed to. And so when the legislature passes a law, when the Congress passes a law, or the executive takes an action, you can take that law or that action, hold it up against the Constitution and say, where is this authorized? Is it authorized? And if it is not to be found in the Constitution, then it's null and void. And to quote the opinion, Justice Marshall says, it is emphatically the duty of the judiciary to say what the law is. So the Congress passes the laws, the executive through the president and his subordinates enforce the laws. But it is, when there's a dispute, up to the courts to say what the law is, what it means, and to determine whether it is consistent with the Constitution. So whenever somebody goes to court challenging something as unconstitutional, they are asking for judicial review. They're asking for the court to review the action of the Congress or the executive against the Constitution and say, is this really authorized?
Yeah. Well, it's interesting too. You know, when I think of the judicial system, in some ways, you know, I think of the, you know, kind of the blind lady of justice holding the scales and, you know, kind of looking at, you know, and balancing. You know, is this, you know, how do we create that balance? And really the founding of the country, the setup of the system of government itself is all about balance, right? On one hand, you have the judicial system who's balancing, you know, what the case before it in front of the Constitution. You have the three branches, which in theory are designed to balance each other out, right? So that no one branch has too much power, right?
Importantly, as the phrase goes, to check and balance each other. Right.
Check and balance each other.
Exactly right. So to give you an example, my branch, the judiciary, all we can do is issue a judgment, a piece of paper that says what we think the law is, and you are ordered to do this or that. That's it. We don't have the power of the purse. We don't have the power of the sword. We depend upon the Congress to fund the judiciary. We depend upon the executive to enforce our judgments. As simple as that. Take the Congress. It depends upon, they can pass the laws, but they depend upon the executive to enforce those laws, and they depend upon the judiciary to interpret those laws. They in turn fund the executive. Executive can't do anything can't do anything for which funds have not been appropriated. Nothing. Well, the judiciary, as he envisioned it, has blossomed into something much larger, much more influential, I think, because of so many disputes being brought to the courts. The courts are asked to resolve many more legal questions than I think ever could have been anticipated. We're much more litigious as a people. I think de Tocqueville noticed that even as early as 1830 when he visited and toured the United States. So as grandiose as the judiciary is compared to what it was at the time, I don't think it's grown in influence or importance beyond more than proportionately to the other branches. The whole government is much greater, not just in size, but in the terms of what it undertakes than the framers ever could possibly have anticipated. The idea that there would be a national a federal government with power, in any power at all, not much, but any power at all over education, which is a state and local function, would have been unimaginable when they framed the Union. And some of those encroachments are perfectly legitimate, and others are probably based on an overly aggressive interpretation of the Constitution, but they're what we have.
Yeah, well, with that, I want to go to the next case that you wanted to highlight, which is a 1905 case, the state of South Carolina versus the United States. Why is this important, and why should people know about this?
Well, the simple point here is that nothing really changed from Marbury versus Madison, decided in 1803, to the South Carolina case decided in 1905. And I think even into about 1935, when I say nothing changed, it was understood and agreed and enforced by the courts that the Constitution meant what it always meant. The meaning of the Constitution doesn't change. The words don't change, except by amendment. The words don't change, the meaning doesn't change. And we've lost that as a unifying principle, starting with some court decisions in the 1930s that created a debate that looms large right now, particularly in the courts and in the law schools, and that is, how should the Constitution be interpreted? If not according to how it was understood by the people who wrote it and then agreed to it and ratified it, then what else? And the alternative, the so-called living Constitution, basically means whatever the judges think ought to be adjusted to meet with contemporary problems. But that's a complete, it's, the judiciary is a non-democratic branch, right? We're not elected, we're appointed. And our power is circumscribed and should be, I think, rather tightly. But to say that the judges can update the Constitution according to what they, or 5 out of 9 Supreme Court justices, think is required, is to assume a policy-making role that belongs to the Congress. Nonetheless, it's happened. I think if you want to roll that first tape, you'll see how the debate is framed.
The written Constitution is all that matters. We, the people, is how it starts.
I'm afraid too many people worship the Constitution. We are being ruled by people who have been dead for 200 years.
How should the living interpret the words of the dead? The debate comes down to the document's original meaning versus a living Constitution.
Originalism is simply the proposition that the meaning of the text of the Constitution must remain the same until it's properly changed.
It's actually very hard to discover often what the original meaning was, because the text of the Constitution often doesn't give you that much guidance.
And I think we delude ourselves if we believe that there is some objective meaning or correct answer.
I don't believe that. If that's true, I can't see the point of having a written Constitution in the first place.
I'm one of the living guys. I believe that the Constitution is ever evolving.
There are going to be circumstances where we have to interpret the meaning of a word. I happen to be fairly limited in how far I'm willing to go.
But originalism does not say, and stick with that through eternity. Article 5 of the Constitution specifically contemplated that the Constitution could and should be amended.
The problem is the Article 5 amendment process is extremely difficult. It's very, very hard. I think the best way to think about a written Constitution is it's a starting point, but it's not the ending point.
Of course, we do our best to understand what the text meant at the time, but for all of the debatable issues, that's a starting point.
If you're a living constitutionalist, it could be whatever you want it to mean. In fact, the only living Constitution is a Constitution that's followed.
That has almost nothing to do with modern judicial review, because in all modern cases of any importance, the Constitution is not clear.
We're not writing on a blank slate, but we are filling in the blanks and figuring out what the Constitution should be.
The Constitution does evolve, but it evolves slowly, it evolves with the time, it needs to be tweaked.
All of us agree that the Constitution should be updated. What we disagree on is who is to do the updating.
That's what the political process is for, to resolve those difficult questions.
The last people you want to be changing that document are judges.
The judiciary is not licensed by the Constitution to add to or subtract from the text of the Constitution.
What the Supreme Court says it means is not actually the Constitution. The Constitution is the Constitution.
The idea that the Constitution should evolve is really inconsistent with it being the law of the land, the supreme law of the land. The alternative is a law that's forever uncertain, no more stable, no more reliable than popular opinion of the time. Opinions change, mores change, the words don't.
Excellent. So coming out, so you set it up and you said, you know, between 1803 and 1905, there's not much difference, right, in how we're interpreting and looking at the Constitution, even though there are big changes in the way the world works, right? If you look in the early 1800s, you have, you know, just the role of the executive. George Washington, for example, is a very different president than, say, Teddy Roosevelt, who comes, you know, in the 1900s. Is very different from what we see today. And so you know, you come down on the side of originalism and explain why that's the way we should be looking at this document.
Well, I think Justice Kavanaugh captured it. There are times when the Constitution has to be updated. It's been updated. We've had 27 amendments. The first 10 were passed in the 2 years after the Constitution itself was ratified. They were added. The other 17 have come along in the last, 140 years or so. And because sometimes very important matters arise, and there's a widespread view that the Constitution needs to be amended. As Professor Strauss said, it is hard to amend the Constitution. It was meant to be hard. It takes 2/3 of the House and 2/3 of the Senate and 3/4 of the states, that's 38 states, have to agree to change the Constitution. So it's reserved for very important matters. Most things can be accommodated by ordinary legislation. If they cannot, then we have to decide, is it important enough to change the Constitution? So, you know, women's suffrage, 1920, well, extremely important, right? More than half the population was disenfranchised, and they became enfranchised. The Civil War amendments, 3 Civil War amendments, extremely important. Ending slavery, assuring equal protection of the law for all persons, and ensuring the vote. Now, the Constitution ensured the vote, but it didn't happen. It took another 100 years, basically, for that really to be reality. But the sense was overwhelming that it should be. We were very imperfect in implementing it. So if you have the Constitution being revised by the judges, as I say, just 5 out of 9 justices, they have no democratic legitimacy. They don't know what the people would prefer, and they shouldn't be putting their finger in the wind to see which way popular opinion is leaning, because popular opinion can be extremely difficult to justify. Popular opinion can often be nothing more than a tyranny of the majority, tyrannizing a minority. When the Supreme Court in 1893 decided the case of Ferguson, what's the word I'm looking for? The case in which they said that the Equal Protection Clause is satisfied if the state provides separate but equal facilities. We had to live with that for 75 years. It was a departure from the words of the Constitution. Separate but equal cannot be equal. It's separate. It's different. And it took a lot of Supreme Court cases, and worse than that, it condemned several generations of the minority, in that case a racial minority, to live in inferior circumstances, to be relegated to the second best of everything, schools, hotels, everything. And so the whole point of the Constitution is to protect the minority, not a racial minority, any minority. religious minority and a minority opinion on some topic. It is to prevent the majority from tyrannizing the minority. And if the court is no better than the Congress, if it's no better than public opinion, then we have no guarantee. We have no bulwark against the majority. Majorities voted Hitler into power. Majorities kept slavery for a long time in this country. Majority has to be reined in by the Constitution.
Yeah. Well, I think it seems like for those of the folks who are, make the argument for the living Constitution, that this process is just, it's too slow, right? And I think we live in an age now where people want something and they want it instantly, right? If I want to hear a song, I can pull it up instantly. I don't have to go out and buy a record or a tape or a CD or anything like that, right?
Well, what they're saying is not just it's too slow, but I don't like the way it is, and I would have to convince a lot of people to get it changed. Much easier to convince 5 justices of the Supreme Court than 38 states to change the law. And if the justices succumb to that temptation, well, it invites further efforts like that.
Yeah, and do you feel like there's also kind of efforts to circumvent that process, right? So I know in the videos, a couple things that you talk about. One, just the incredible growth of regulatory agencies, which you make the point that really these regulatory agencies are 3 branches combined into one.
Yeah, the first sentence of the first article of the Constitution says all legislative powers granted herein are vested in a Congress of the United States. All the legislative powers. And what the Congress has done is, because if they exercise their legislative power, if they say, we're going to make certain decisions that are going to be hard on many people, well, that's controversial. That's unpopular. They're going to lose votes. They're going to lose financial support for a re-election. So it's much easier to say, let's kick that over to the executive and let them make the hard decisions. So instead of voting for a particular degree of pollution control, let's just vote for clean air and help turn it over to the Environmental Protection Agency. Well, that avoids having to offend anybody, right? Clean air, sure, everybody, great, we're all for clean air. Well, then it comes down to actually making the decisions about how that's going to be achieved. And it means some factories are going to be closed and some jobs are going to be lost and some rivers are going to be polluted and some are not, and so on. And the EPA makes those decisions instead of the Congress. Well, that's not representative government. They have departed from the model that we were given, in which they legislate and the executive implements the law, to saying to the executive, go ahead, you make the laws. So now there are about 18 regulations every year with the force of law put out by the agencies for every one law passed by the Congress. So who's making our laws today? It's the alphabet soup of agencies. It's the Federal Trade Commission, the Securities and Exchange Commission, the Consumer Product Safety Commission, the Consumer Finance Protection Board, and on and on and on. There are scores and scores of them. So who do they represent? They don't represent citizens at all. These are agencies headed by sometimes one person, sometimes 5 persons, and a majority of them may represent the president's policies if they were appointed by the current president. Well, they would be appointed by the current president, whoever that is at any given moment. But that's very indirect. I mean, we write to your congressman when you have a grievance, and all you get back is, well, I'm sorry, that was the EPA. Nothing I can do about it. I voted for clean air, by the way.
Yeah.
So it's a complete default. Then they authorize the agencies not only to issue regulations that have the force of law, legislative activity, but to enforce them, the executive activity, and then to judge whether the citizen violated them, judicial activity. James Madison said the combination of those functions in one hand is the very essence of tyranny. So you go before one of those agencies accused of violating one of their regulations. If you don't have a lot of time and a lot of money, you have no chance of getting to a real court to review what their decision was. to say, they said, well, you violated the regulation, you're fined about $12 million or $150,000. And now it's been 2 years, and you could go another couple of years going to courts to get the courts to review that decision. And worse than that, the courts have been told by the Supreme Court, don't actually review the decision, just make sure it's not completely unreasonable. So if the agency says the statute means X, court can only ask itself, well, is that an unreasonable interpretation of the statute? I think it means Y, but it's not crazy to say it means X. So I guess we have to acquiesce in that. So you have these agencies performing all three functions totally against the Constitution, and then being allowed to have essentially the final word on what the law means, contrary to what I said, quoted from Chief Justice Marshall. It's emphatically the duty and province of the judges of the judiciary to say what the law is. When my colleague Judge Bork resigned from the DC Circuit, and I tried to persuade him to stay, he said to me, I just can't go on deciding whether the secretary was reasonable.
That's a great point.
That's not the Constitution we were given, Tony.
Yeah. Well, I want to jump back in. I know there was a point, and you talk extensively about the Commerce Clause in the video too.
Yeah, so this is very simple. The Congress shall have the power to regulate commerce among the several states. Commerce means trade. That's not controversial. Among the several states meant any trade that crossed a state line. It also came to mean, and I think correctly the Supreme Court said, it also means the railroads and ships that cross state lines to bring goods. So the Congress has regulatory authority over interstate trade. And that means it didn't have authority over labor relations, mining, manufacturing, retailing. And that's what so upset President Roosevelt in the 1930s, because in the emergency of the economic depression, he was continually proposing, and the Congress was passing legislation that dealt with things that were beyond the power of the Congress, under the Commerce Clause or anywhere else. But in 1937, the Supreme Court started to acquiesce in this idea that even if something didn't cross state lines, it nonetheless came within the authority of the Congress to regulate. Take a look.
Ernest Hemingway slept here. Now they do, descendants of Hemingway's six-toed cats. The Hemingway home is dedicated to preserving the legacy of author Ernest Hemingway and of his cats. In Key West, anything goes. Chickens need no reason to cross the road, or a license, for that matter. But when the Federal Department of Agriculture got wind of the museum's cats, it dictated how they should be cared for.
The museum challenged it on Commerce Clause grounds and said these cats are marooned at the very southern tip of Florida, will never cross a state line, and furthermore, they were not bought or sold, they were merely born.
To the framers, commerce meant I send something to you in Boston when I'm in New York. That was interstate commerce of the kind that could be regulated. When two people in the same state traded something, that was not interstate commerce and therefore could not be federally regulated. That was the intention of the framers.
The framers didn't design an almighty federal government that could reach down right into your backyard or barnyard.
During World War II, there was a farmer who grew grain, and he fed that grain to his own animals.
And the federal government had a program at the time that dictated how much wheat farmers could grow on their own land. And he said, hey, that's not constitutional. Why? Because I'm not engaged in interstate commerce.
But in Wickard versus Filburn, the highest court in the land thought otherwise.
And in a convoluted analysis, the Supreme Court declared that because that wheat would not be used in interstate commerce, it still impacted interstate commerce through some type of displacement.
So they're taking the Commerce Clause and stretching it like a rubber band to apply to any kind of business when it was originally meant just to be for cross-border commerce, like it says.
I agree, but some scholars disagree. In their view, there's little, if anything, beyond the regulatory authority of the federal government.
In an economy like ours, things really are interconnected. And what goes on one farmer's farm really does affect what happens elsewhere. And so when the Supreme Court says the Interstate Commerce Clause gives Congress the power to regulate things that seem awfully local, it's not just engaging in some kind of trap to expand federal power. It's recognizing an economic reality.
If the test under the Commerce Clause becomes, does it affect commerce, then everything affects commerce, whether you do something or don't do something.
Well, once you have the power over anything that affects commerce amongst the states, then you basically have the power over everything.
Everything? Even Hemingway's cats?
The 11th Circuit Court of Appeals, and I kid you not, said that because the museum features these cats on its website and has cat-related merchandise in its gift shop, that is a substantial connection to interstate commerce, and that opens the door for the federal government to come in and exert control. Not making that up.
Excellent. So I found that clip just fascinating. One, I was a literature major and loved Hemingway, and the fact that the federal government needs to get involved with six-toed cats and selling cat socks on a website just seems to me incredible.
Yeah, I mean, really, it is. It's that's why he said, "I kid you not," right? Because people would hardly believe that that's interstate commerce. In fact, it revised the Interstate Commerce Clause, which we saw before, quite substantially. Can we see the slide that shows that, Tony?
Yeah, and this is referencing Wickard v. Filburn, right, 1942?
Schley is described there, the wheat case. So let's look how apologetic this is. Even if it's local and may not seem like interstate commerce, and even if the effect is indirect, it's still within the reach of the Congress if it has a substantial effect on interstate commerce. Now, do the cats and how they're fed and cared for in Key West have a substantial effect on interstate commerce? Well, as a practical matter, what has become of this is all the one need show is that it has a discernible effect on interstate commerce. Obviously very indirect, since the cats never go anywhere. They're just on the website.
Yeah.
So basically the federal government has been able to reach into, yes, your backyard.
That's it. And the word substantial seems very important there. It's how many cats is a substantial amount of cats? Is it one cat? And then, we have 10 cats now, so the federal government has to get involved.
Yeah, President Reagan understood all of this. He was very thoroughly educated, mostly self-taught, in the political theory of the founding. The books, and I've seen some of the books in the library, in his library that are in the Reagan Library Museum, with extensive annotations in the margins. And he used them in his speeches for General Electric for, a decade or so. He really had a very thorough education in political philosophy and political theory.
Absolutely. Well, then, so the next bit that we have is the Commerce Clause as revised. So do you want to talk about this?
This is what we were just discussing. Right? So really, it's just now matters substantially affecting commerce among the states, and substantially doesn't mean anything.
Yeah. Well, and then the next thing we want to talk about from the Fifth Amendment, the Takings Clause.
Yeah, this is a more recent outrage. So here's the Takings Clause of the Fifth Amendment, part of the Bill of Rights. Nor shall private property be taken for public use without just compensation. Now, we all know what private property is. It's not controversial. Just compensation is not controversial. It means the market rate, not your sentimental value on something, but the market rate for your property. But the question that arose a dozen years ago was, what is a public use? And intuitively, it's not a hard question, right? A road, a county courthouse, a school, public uses. In the late 19th century, the court had some cases involving things like hotels and theaters. And they said, that's a public use too, in the sense that the public uses them. We don't mean that, because they don't serve a public purpose. So it's really got to be a sort of public use and understanding that means something of a public purpose. Well, the court then totally distorts and changes this just a dozen years ago. If we can see Charlie's case in New Jersey as our example.
As a kid growing up with pianos, I remember the first time I ever broke a string, my dad said, "You broke it, Charlie, you're gonna fix it." The first musical director of one of the casinos, he came to me and said, "Charlie, I have a lot of pianos here." So that's what started my career in piano tuning in Atlantic City.
At the beginning of the 20th century, Atlantic City was America's playground. But after World War II, its fortunes declined. The city then gambled on casinos and lost big. Much of America's playground is now a casino wasteland.
This building is not just walls. This building is a cross-section of my life. It's like a living, breathing thing. We were blessed to be able to come as immigrants to this country after what my parents had survived the Holocaust. And the idea of actually owning something that we couldn't be thrown out of was huge.
But maybe Charlie could be thrown out. In 2014, a state judge ruled the Casino Reinvestment Development Authority could seize Charlie's home, using the state's power of eminent domain.
And you have 45 days to vacate, and that it would be bulldozed as all the other buildings right next to me had been bulldozed.
Does the public use provision of the Fifth Amendment have any meaning whatsoever? And the Supreme Court's answer by a 5-4 vote was effectively no.
The Constitution provides that private property may be taken for a public use with just compensation paid. But the Supreme Court rewrote public use to read public purpose, which is much broader.
And the thing that was crazy in the Birnbaum case is they weren't even sure exactly what they were going to use it for or when they were going to use it.
They said, "We don't have to give you an answer." I'm thinking, where do we live? Is this Russia? Is this North Korea?
It's just a naked abuse of government power.
So Charlie went to court. 2 years later, the judge deemed the state's effort to oust Charlie a manifest abuse of the eminent domain power. New Jersey appealed, but in the end, Charlie prevailed. In the infamous case of Kelo versus New London, Suzette Kelo wasn't so lucky. The Supreme Court said, we can't decide what a public purpose is. We'll let the city councils decide that. That's good enough for us. Funny, but I had thought the justices were supposed to make constitutional decisions.
So the battle goes on.
So, you see, Tony, I mean, Kelo had laid the groundwork for this. I mean, New Jersey lost, but why would they even try? Why did they think they could do this? Because in Kelo, the city of New London said, we want to raise all these houses here and clear this space, this block for Pfizer, the pharmaceutical company, to build a complex with offices and research and so on. They'll pay much more in taxes, real estate taxes, property taxes, because the property will be worth much more than when it has these houses on it. And the Supreme Court said, well, yeah, that's a public purpose. And how do we know? We know because the City Council of New London voted for it. Must be a public purpose. So that was such a departure from public use, from saying, you know, a school or a courthouse or a road. And it was a complete shock. And in the aftermath of that, 46 states have changed their law or made it clear that their law does not authorize that kind of taking. But that, in many cases, they did it by statute. Sometimes it was court decisions. But some of them are very clear and firm. In Florida, for instance, a municipality cannot take property except for a public use. If it takes something, it cannot sell it for 10 years, so it's got to use it. Can't just turn it over to a Pfizer. And to get an exception requires an act of the legislature, both houses, and the governor's signature. So it's very serious about it. Other places, not quite so much. And the federal government now can take things for a so-called public purpose. See, let's take a look for just a moment at what they did to that clause. We saw the takings clause. Can you put up the way it reads now?
Oh, sure.
Here's what they said in the opinion, in the Kelo opinion, right? Changing it to a public purpose. And here it is, a public purpose such as economic development that will raise more tax revenue. Now, that's not interpretation, that's revision of the Constitution. And if you didn't think so from just looking at it, bear in mind that 46 states rejected it. Said, not in this state. That's not our understanding. This was so destabilizing to the property people own that it was intolerable. And why? Because it was a huge departure from our understanding of the Constitution.
Yeah, absolutely. I can only imagine if you're a homeowner and your city, your local government says, well, we think we can make more money if you will take your house, in the Birnbaum case that you were showing there. I mean, it looked like his family had lived there for generations. And just to have, those memories and that family history kind of forsaken for the purpose of additional tax revenue seems silly. Another question for you, something that you talk about extensively in the video, and I think something that people are interested in. We're a presidential site here at the Reagan Library, and so there's often a lot of controversy and discussion back and forth on executive action and executive orders. And in the video, you gave two examples, one of which I think many would argue positively about, the Emancipation Proclamation. The other, Roosevelt's Executive Order 9066, which authorized the incarceration of Japanese Americans. What do you think, or what should the public know about executive action?
Well, the president, is the chief executive. He has to be able to, on a daily basis, issue orders, directions to his subordinates, who are now 2 million civilian employees, by the way. That's how big the federal government is, not to mention the defense establishment. So he has to be able to issue orders, and that's a perfectly legitimate function. Now, what does the order require? The Emancipation Proclamation was a military order. It was issued by President Lincoln in his capacity as commander-in-chief, and it freed the slaves only in the areas that were in insurrection. The military districts that were so-called, that were essentially the Confederate states that were still in a state of insurrection. And that's why when the war was over, we needed the 13th Amendment to put a real end to slavery everywhere and forever. Executive action can be revoked or changed by the next president. That's what happened when President Obama entered the climate accords, the Paris Climate Accord. President Trump just rescinded that. The Iranian deal that President Obama entered into in order to contain Iran's nuclear weapons development was something that was, I think, perfectly clearly a treaty, not an so-called executive agreement. Now, executive agreements are also legitimate, like executive orders. There's no reason that you have to have the Senate confirming a decision of the president that we will open a consulate in a secondary city in some other country, not the capital, which is done reciprocally so that other country can open a consulate here. But this was an important matter, this Iran deal. It was huge in money and strategic significance and so on. And he didn't submit it to the Senate because obviously the Senate was not, everybody knew the Senate was not going to ratify it. How many senators stood up and say, wait a minute, you got to submit that to the Senate? Fewer than a half a dozen, I believe. So there was another executive order, the executive agreement in that case, that is a really questionable legitimacy, but in any event, revoked immediately by the next administration. Now, President Roosevelt, as you said, issued an executive order interning all the Japanese Americans on the West Coast, essentially in camps. That was also justified as a military necessity. The justification was very thin compared to, for instance, the Emancipation Proclamation as a military matter. It was a bit of hysteria, I think, at the time. It's difficult to go back and judge and really understand how people felt and what they feared. But I can tell you, having grown up in the Midwest in the 1960s, when nuclear war was a threat, we were hiding under our desks, right, in a school drill in case there was a nuclear explosion, as if that would do any good. But that was the mentality at the time. I don't mean to excuse Roosevelt's internment, and the Supreme Court did approve it at the time. They've since regretted that. I think should say repudiated their own approval of it. But that was a very difficult call at the time, I think. So President Clinton issued an executive order. I can't imagine a more legitimate one, directing all the departments and agencies in the executive branch to make decisions where so far as consistent with the law, that tended to implement or favor his so-called American Rivers Initiative. Somebody actually challenged that, and I had the case. I mean, of course the president can tell his subordinates where the law allows it, this is what I want you to do, try to clean up the rivers. Perfectly ordinary executive branch business through an executive order.
Yeah. Well, we have about 6 minutes left, and so I have just a couple questions left, and then I'll give you a chance to kind of make sure you plug the series in the book and that sort of thing. But you mentioned, the Iran agreement. In the video, you also talk about declaration of war, which is a power explicitly given to Congress, which hasn't happened since World War II. There are some who argue that Congress has in many ways ceded some of its constitutional power by not standing up, as you note. How come the Senate didn't stand up and say, hey, this is a treaty, we need approval? Or how come the Congress doesn't stand up and say, wait a second, you can't send troops over there, we need to declare war? Do you think that in terms of checks and balances, that we're at a place in history where those balances are out of whack, that there's one branch that has assumed too much power?
Well, with respect to the war powers, yes. Clearly, there are circumstances such as an attack on the United States in which the president may need to act immediately. Even in the case of Pearl Harbor, President Roosevelt, when we were attacked, went to the Congress for a declaration of war. We've never lost a war that was declared by the Congress. And every war declared by the Congress has the full backing of the people, because otherwise their representatives wouldn't endorse it, wouldn't authorize it. So when you get a very controversial war like Vietnam, it was never declared. Now the Congress did, of course, continue to appropriate money. They passed a resolution, the Gulf of Tonkin resolution, that President Johnson interpreted as though it were a declaration of war and gave him authority to do virtually anything he wanted in Vietnam and the immediate theater around it. The authorization for the use of military force passed by the Congress in 2001 was the basis for President Bush's interventions in Afghanistan and Iran. Considering the background for that, the attack on the Twin Towers in New York and the Pentagon and what probably would have been the Congress had that plane not gone down. I think the authorization for use of military force was pretty clearly aimed at and justified with respect to Afghanistan. The president took it into Iraq on his own without going back to the Congress. So I think things have gotten, when that happens, we're out of whack, And it's civilian control of the military, which is one of the points in the video that I discussed with former chairman of the Joint Chiefs of Staff, is an extremely important principle. The framers were quite familiar with Julius Caesar and every general for the last 2,000 years seizing power over a republic, and made it quite clear that there would be civilian control of the military.
Excellent. I want to wrap up with a couple of questions. Your career has had some interesting intersections. I wanted to ask you specifically, you mentioned in the video that when you were clerking, you had a chance to clerk for one of the arguably great legal minds and legal influencers in the history of the country, Thurgood Marshall. So I was wondering if you could just share a memory or two about that experience.
Well, everybody knows Thurgood Marshall, if they had a civics class, as the architect and winning lawyer in the school desegregation cases in the mid-1950s in the Supreme Court, the culmination of a 20-year campaign organized by Justice Marshall and and his colleagues, Walter White and Spotswood Robinson and William Hastie. And it was a great accomplishment, no question about it. But most of his career, up until the time he went on the court, first the Second Circuit in New York and then the Supreme Court in the mid-'60s, President Johnson was spent defending blacks accused of rape or murder, usually a white victim and a black defendant, in the Deep South. And he took his life in his hands almost every time that he went from New York down there to defend those cases. His life was threatened and almost lost on more than one occasion. He was about to be lynched when a sheriff's deputy came along and broke up the party. There were times where, I mean, he couldn't stay at a hotel. He would stay with families at well-hidden places. He's the bravest person I've ever known. And I doubt I'll ever meet anybody else that brave.
Thank you. It's a beautiful memory and just a reminder of his impact and his bravery. And then the last question I have before we wrap up is you had a chance to work in the Reagan administration. You met President Reagan, somebody who's very near and dear to the hearts of the folks who work here. Any memories about Ronald Reagan, the man?
Well, yes. I had, I think, 3 or 4, maybe 4 occasions to interact with him at some length. They were always very rewarding because he not only grasped and was interested in the issues, but always had an appropriate story with which to illustrate his points. I learned a lot in every one of those encounters, even about antitrust, my own field, when he talked to me about I gave a presentation to the cabinet and about legislative reform for the antitrust laws. And when the meeting broke up, he said, "Doug, let me tell you what happened when the antitrust laws broke up the studio system in Hollywood." The case was, I think, in 46. And it said that the studios that made films could not own exhibitors that distributors or the exhibitors, the movie houses. And it totally changed the industry. And it had the opposite effect of what it was intended. Of course, it was intended to make the industry more competitive and to stop some anti-competitive conduct, or so it was thought at the time. And it explained how it concentrated the industry. It changed it reduced the number of studios that were viable. It changed everything in a way that no one anticipated, and was actually counterproductive in some ways, in making it less competitive. So that was sort of illustrative of the way in which he could bring, in that case, history of his own knowledge, within his own knowledge, to bear on a topic and teach something about it. But to give you an idea of how different the times were, when the president nominated me for the Court of Appeals of the D.C. Circuit, where I've been for the last 34 years, it went to the Senate late in the term. They were about to go home it was the end of a Congress. They were going home for November elections. I got a hearing in September and a vote, I think, in late October, just days before they broke up and left for the 86 elections. Who introduced me to the Judiciary Committee? Senator Kennedy of Massachusetts, because I was from Massachusetts. So here was an illustration of how things have changed. That just wouldn't happen today for the chairman of the committee in one house to introduce the president of the opposite party's nominee for an important post.
Wow. Well, thank you for sharing that story, and thank you for joining us today, Judge Ginsburg. I encourage everybody who's watching us, please, you can find his video, A More or Less Perfect Union, on Amazon Prime. Is there anywhere else they can find it?
PBS Passport for those who are members. It's free on Amazon Prime, and also at freetochoosenetwork.org. Has it as well, plus my interviews with George Washington and Benjamin Franklin, and some teaching materials for the schools on affirmative action, on the history of race cases in the Supreme Court, called Becoming Equal. There's a lot there.
Excellent. So we encourage everybody to check it out, and also make sure you pick up the book, Voices of Our Republic, Exploring the Constitution with Ruth Bader Ginsburg, Alan Dershowitz, Sandra Day O'Connor, Ron Chernow, and many more. It's a beautiful coffee table book, and if you're sitting at home anyways, you might as well learn a little bit more about the Constitution. So with that, Judge Ginsburg, thank you so much for your time today. We appreciate it tremendously.
I'm only sorry I couldn't revisit the library to do this with you.
Oh, well, you're welcome as soon as we reopen.
See you
Right.
then.
Thank you.
We hope this conversation has inspired you to share what you've learned with your family and friends, and that you'll join us again for an upcoming event.
And let me offer lesson number one about America. All great change in America begins at the dinner table. So tomorrow night in the kitchen, I hope the talking begins. And children, if your parents haven't been teaching you what it means to be an American, let them know and nail them on it. That would be a very American thing to do.